good fraternity is usually one of the which once that bulwark is broken, a society will disintegrate. And by the way, we have been here before. Many may not know, in fact, I believe it was Elison who told me about the late John Kazuo, how he survived assassination, mainly because he went out for lunch. And when he came back, his entire office had been shot dead. Lawyers have worked under very extraneous circumstances. But when you speak to people like Chief Justice Mwambuzi, who is now retired, I remember him recounting to me a story that stayed with me. He said they were writing a piece of legislation when he was first parliamentary counsel. And President Obote had a view, but so did his Attorney General, President Binais, as he would later become. And he turns to the President and says, what do you think? But the correct answer contradicts what Binais Akisi was saying. He found his tongue with a really clever way out of it. But the issue then was that at least he had the opportunity in that tense situation to render an opinion. And that we should never lose. And I would urge anyone in authority to see lawyers for who we are. We represent people who have pains, dreams, joys. And just because I disagree with you doesn't make me your enemy. But the day we lose the right to disagree, people who disagree through us or whom we represent will find other means to express themselves. And that, I believe, is what Robert Bolt called a short route to chaos. And I think it's unnecessary, but again, I return to where I started from. I hope that we as the bar, we as members of the profession, will never lose the right and, importantly, the voice to speak in unison and attack on any lawyer. It does not matter whether this lawyer came out of LDC yesterday or has been at the bar for 25 years. It does not matter whether this lawyer is making a solid argument or because you see, any argument in the view of the person making it is solid. Now we can disagree on methods, but we should protect very jealously our right to practice law, and we should be able to do so freely and in a society where we are not worried about it. Because you see, if I look at what happens to a colleague in a political sense, and I won't go there, which is the easiest thing to do for many of us. What you have done in censoring yourself essentially is postponing. You're kicking the can down the road. Things that don't look like they affect us are usually just one doorstep away. I always tell people that one mistake you will make is to assume that a bad decision has to be from you to affect you. It doesn't have to be your decision. And I remember when our colleague, and I hope he doesn't mind, I think that we know each other well enough for him to not take offense if I use him as an example. If you think about our colleague, Aaron Kiza, many people came and said, but he overreacted. Auntie, because you were not the one in that situation. But you see, he went to the General Court Martial to represent a client. And that is a point that we should never lose sight of. We can disagree on his methods. But when a colleague finds themselves in a spot of battle, before we come out to say it serves him right, or but why did they do that, I hope that we can strip the situation away from the politics and look at it for what it is. A lawyer woke up in the morning to go and represent the client. That's the point. And hopefully no authority in this country should be able to stop that from happening. That, for me, would be my honest, candid, unvarnished view on that point. And importantly, especially for all of us who are still actively practicing in whatever sphere, across any domain of practice, academia, private practice, the courts, in civil society. I hope we never lose our courage to speak.
Thank you. And thank you, Robert. If you're just joining us, welcome to the Judicial Service Conversations, the Parliament of the Bar. Today we have Mr. Robert Kirunda, reimagining the future of legal practice. And the first thing, the first point we have come to is that we must respect the right of the advocates to advocate for those people who instruct us, to dispute on behalf of the disputants. In that same spirit, I want us to move to another area. Maybe I'll just hand over to my colleague, Mr. Alfred Muyaka.
Thank you. The lawyers who are Elison Karuhanga and lawyers who have to host council by sure now going personal questions. I almost brought you this candidate and you know they have to deal with that's where there's maybe at one point get into that. But when we reported host to one of the things which was the main was Robert Kirunda saw it, I think, as if Robert Kirunda saw it like before us. And we went and learned about everything, and now it was obviously AI. So my question was going to regard AI. We have young lawyers in the room here who have been told that AI are the best lawyers, including you. And I'm also maybe, you have been requesting, I don't know. So my first question is, when people say that AI will change how you look at you, that replace lawyers, what exactly do they mean? And realistically, what are those aspects of the lawyer's daily work which AI will transform, and what will remain unaffected? So that I think people have been trying that at least AI may take everything, but lawyers will still go to cross-examine the people. It can't do that bit. So wondering what aspects will it change and what will remain and what are the change?
So actually you raise a fantastic question, and technology is where I have planted my tent peg for now. I am indeed very interested in emerging technologies, especially AI. Now, so I'm saying that AI is indeed a place where I've planted my tent peg, and it is a fantastic question. The problem with this question is that it usually arises in contexts where we can't only discuss it at surface. So let me start at the beginning. Let me try and summarize it and then explain. It is true that AI has disrupted legal practice. I've chosen my words very carefully to mean. People say it will. No. It already has. And it is okay for you to say, not to me, not in Uganda, but I think that would be a mistake. And I would especially urge every member of the bar, we are focusing too much on young people, but that's not where the disruption happens first. Why? Because young people adapt faster. Elison and I will easily argue about how old we are, but the reality of the matter is that we will struggle to adapt.
Is that we are young?
Is that we there you go. But let me try and break down a few ways in which I think that AI is affecting us. Number one, entry-level positions. You see, when Elison and I hire young lawyers to join us, the first task we will trust them with is research. Can you write me an opinion on this file? Why? Because we are liberating our time to focus on the more complex task, which is advise the client with context and nuance. Typically what a young lawyer will do is come and say to me, the legal position is, the authorities are. I must then take that position and go and tell the client, while the legal position is, the facts here say, and you may also want to think about, and that is context. That context comes from experiences, the things I have done well over the years, the things I have done wrong over the years, the stories I had from Elison, and that the young lawyer doesn't have yet. AI does not have that context, but AI will definitely give me an answer faster on a research point than any young lawyer I have ever worked with. And believe me when I tell you, I have worked with some fantastic young lawyers. Simply fantastic. Where they give me a document, and even I think, my goodness. In fact, a gentleman who worked with us and has now moved on to another workplace, who was somewhere else, and one of our friends was teasing me and saying, Robert, man, this guy stole your colleague. And I turned to him and smiled and said, how is my young man doing? And this man said, man, he trained for me a miracle. He is that good, and I'm very proud of him. But AI will deliver that result faster. If I ask the right question, legal research is much easier, much faster. Which means that instead of hiring 10 people, I can hire 3 people whom I trust to use AI well at the entry level. Now, the second thing is, if I need to write certain documents, if I have to write submissions, and I am careful on how I am using the tools, then I am going to have a superior product, and therefore I have an edge. I know, as an academic, I try and keep up with how universities are admitting people, and some universities are saying, don't use AI in your application because it will give you an unfair advantage. Now think about that in the context of a courtroom where one lawyer is using AI well and the other is not using it. Right? And the easiest target here has been, yeah, but AI can hallucinate. And therefore you'll end up with cases that were made up. But there are people who are using AI properly and they don't deal with that problem. Also, I can tell you from having used these tools over the last 1 year that hallucination is not as bad today as it was 1 year ago. These tools are improving very, very fast, and it is only a matter of time before they get where they really, really need to be. In fact, in computing terms, those who are building the tools are telling us every 6 months the growth is far more exponential than I've seen before. Third area, if you go to transactions, M&A, mergers and acquisitions, I think is the one place we've seen too much disruption. There are now tools that can spot. One time I was talking to my dear friend James Kirunda, and he was telling me, I have noticed why big firms do better than us. I think he had been on a deal with another friend of ours, and they were slapped with a 200-page document and given 18 hours to respond and share their views. And so we're talking about this experience. And you see what happens at a firm like Clifford Chance or Slaughter and May is that one deal will have 25 lawyers, 3 lawyers on IP, 2 lawyers on tax, 4 lawyers on warranties. So everyone is reading their 5 pages, and they can do that in an hour. When you put all that together, these guys are like magicians, but really all they did was they had scale. Now AI has helped smaller firms to do that at scale. Again, if they do this thing. Number 4, litigation support. I've touched on that a bit, analyzing court judgments and figuring out which case is better than what. Did you know, for instance, Alfred, that the industrial court is building its own internal AI? The industrial court in Uganda, of all places.
Why them?
No, the leadership there decided, you know what, we can't ignore these tools, let us find a safe way to learn how to use them before lawyers get ahead of us. Now, when you appear before a judge who was prepared to hear your case, and they have used AI, you can see how already if you go to court against Elison, who is an experienced a litigation machine, you are at a fairly significant disadvantage. For no fault of your own. He was born earlier, he worked his way up, and he has earned his right to be in a court and be a master of the art. One of the things that I really think we underestimate in the legal profession is the power of seniority. And before you diss me on this value, think about how much you learn when you go to a court where a judge is active, serious about oral submission, and you sit back and watch. If you have seen, and I will mention some people's names whom you can all relate to, and I'll tell you, go to a court and watch Karibalaka. Just watch. Just go and watch James Mukasa Serigeni. Go and watch Masimbe Tangerezi. Go and watch Elison Karuhanga. And you will see, you just enjoy hearing these people argue, especially if an argument starts with a judge. And we learn through those things. Now the judge is saying, instead of 10 researchers, I have this AI tool that helps me to read the record quicker. It is a fact of practice that a better organized record gets more attention from the bench. Now, if I throw a record of appeal of 2,000 pages at a young lawyer and I say, handle, they will spend 6 hours with a brain freeze before they figure out where do I start. AI has simplified that. Now, I was that young lawyer, so I'm using myself as an example, where they throw you in the middle of a deal and they're thinking, where do I start? I can tell you that in an arbitration I handled, when we were filing our submissions for the arbitration to handle, we had 1,400 pages of text. There's just no way, as a lawyer, and by the way, we had 2 weeks to put that together. I was fortunate to be working with English counsel who do this for breakfast. So you can imagine scale their help. AI is simplifying that. Now, we usually like to look at it as replacement, but really think about the opportunity. Also, client communication. You would be surprised how many people struggle to write a decent letter. When I help out my family, the first thing I obsess over is how do you write. Why? Because when we send a letter across to Kampala State Advocates, somebody else says one of two things. Either which moron wrote this, oh my goodness, what a beautifully written letter. There's only two possible reactions to a document. If I get a letter and I'm struggling to look for the point, I will respond a certain way. Now, if I am doing strategy and I say, let me find a tool that can help me to communicate better, it's going to help me. So, entry level, unfortunately, and this pains me to say as a person who is at the law school, entry level positions have changed. There's another trap. And this is what we are not discussing yet. As a person who uses AI tools, I can spot a document written by ChatGPT. And if I receive, and this actually happened to us. We put out a call, we were recruiting, and we received 70 applications. And in the course of saving, we could very easily detect this person used AI. Most of those we just put away. We didn't give them a second look. So it will disadvantage you. The biggest mistake you can make is putting the cognitive load on the algorithm. A book I recommend to anyone interested in this is
putting the what?
The cognitive load. Delegating the thinking to the algorithm. Don't do that. If you want to use the tool, start with your position. Me, what is my argument?
So you start with natural intelligence.
Aha.
Before you go
artificial. I went to Court of Appeal once in this really interesting case, election appeal. And I was arguing. They asked me a question. I said, why don't you answer that question? The decision is all the time. And one of the justices I will not mention says, that's what the case is. You what's your view? I said, no, my lord, the nature of the law is that I am not allowed to have a view if I have a decision. It is binding on you. It is your decision. No. Put it away. What is your view? I put it away. And I raised an argument. My own. Now, that is the iPhone. The moment you go in, see, one of the types of bias you rarely hear about is confirmation bias. Many times it will not argue. You say, you are right. We'll see what Apollo Makubuya, one of our senior colleagues, has a story about a man called Selana Chita. I don't know if you have heard this one before. Sir Edward Mutesa, Kawaka Mapuganga, had a dear friend whom he used to love going hunting with. The problem was that every time they were going out, Selana Chita, today should we carry sliced bread? Or the one which you don't use sliced? They'd say, Sam said that I think we should carry bread. Yeah, sliced and sliced. We should carry sliced bread. Hey, but you know, unsliced bread is good because it is thick. Says, Sarah said you are right. Actually, let's carry unsliced bread. Okay, should we carry milk tea or black tea? You're right, Sarah said we should carry tea. Yes, but I think milk tea is sweeter because it's more nutritious. Yeah. Sarah said you are right. It is actually sweeter. But wanted to make us hungry faster. You know, Sarah said you are right. So AI is like Sevana Chita. in some contexts. It will tell you what you want to hear.
You're always right.
You're always right. And the problem with that is that then you will never tell when you are crash landing, right? So there are many ways, but I'll even tell you another non-technical way, away from the technical work that lawyers do.
I think I know Savannah Cheta's family.
There you go. One way is how we run our business. You see, now there are advantages that big firms have because of scale. One advantage is that if you use these tools well, you can scale faster. 5 people who know how to use AI well can do the work of 20 people, for example. The other thing is administrative tasks. If a task is repetitive, it is done by people, it involves standard work, it can be automated. AI will do it faster and arguably better. Is there a downside to AI? 100%. One, hallucination. Two, and that can cause sanctions. And I believe, by the way, that the rules, the professional ethics rules we have today, the advocates' professional conduct regulations, have enough wording today to cause you problems if, for instance, you cite cases that don't exist. Right? Now, guard against that. But that's why I keep saying use the tools well. Number two, there will come a point where we are now suffering a much worse version of bias, where the decisions we are getting are skewed towards a certain dimension. That's just inherent. That's just a result of the inherent bias that lies in the tools. Number three, we will likely end up with decisions that are aloof from the human condition. You see, one of the things that makes us really, I was recommending a book, then I stepped out from it. Let me go back and finish that sentence. A book I recommend is Kaifuli's book, AI Superpower. It's a bit old now, having been around 2018, 2019, I think. But the major lesson, one of the very, very vital lessons about that, from that book is that ultimately Kaifuli argues, and this is one of the leaders in the AI industry, at least early leaders, he argues that what will distinguish us in the age of AI is our ability to be human, to empathize, I'm sure, Elison, you've been in court and seen a place where you could press the point further, but out of just respect or even sympathy for your colleague, sometimes much younger, sometimes you don't press the point too hard, you don't press for too much in costs, too much in damages. Our dear brother Nicholas Appeal one time told me something very fundamental. He said to me, he learned a lesson early in his career that leave enough room for your friend to escape when you have them in a corner. Because next time it might be you in that corner. And that's just about us being human. And I hope we never lose that. Now, AI does not have that. AI cannot empathize. When you're prosecuting a witness and you see them breaking down, must you press to the end?
I think I'm like, yeah.
All the time, I was like, that's
Elison will go the whole way. But you see,
No.
there will be other situations. For example, should you settle? A simple question. Should you settle? Or should you go the whole 9 years? There will be cases where, and I have done cases where, you can litigate and win. But nobility suggests that maybe he is worthy to settle. Right? Now AI can't do that. So I hope I've given you some context. So practically speaking, the economics of legal work will shift. Clients will pay less for volume and more for judgment. They will trust. What we are going to trade in isn't just correct answers. What you're trading in now is judgment. Are you practical in your advice? So those who stick to the traditional will be priced out. And also, I think, in some way, lose many advantages. And lastly, at this point, the terrain of what makes it, the measure of what makes a really good lawyer, I think, has shifted from accuracy to value. You see, I can cite 25 cases, or I can come and say, the law is on your side, but you should settle. And the client will settle because the lawyer said so. What that does is that it gives me currency with my colleague, Joey, to go and say, I need a favor. You see, of course there will be cases which you can't do that. Election petitions. Those ones are winner take all. Either someone won the election or they didn't. The stakes are high. But there will be cases in negligence, in commercial matters, where the algorithm will tell you you have a high chance of winning, and they will ask you what was. So from where I sit, there's another. I keep saying one last point. This is the last one, I promise. And maybe this I would suggest as just my thought. When I look down 10 years from now, whether you like it or not, think of AI like secretaries. When we left law school many years ago, I'm going to keep reminding you how old we are. Law firms are typing pools. I don't know how many law firms are typing pools today with secretaries who type. You would write your submissions. I know Gen Zs won't relate, but they would give you a file and you would handwrite legal memorandum to Mr. Elison Karuhanga, comma, partner, from Robert Kirunda, comma, clerkship student. Subject, I did my clerkship at the law firm of Shonimuso. And then you would handwrite brief facts. And then you would go to the typing pool and you would line up. And depending on the mood in which the secretary was, they would prioritize who goes first. And that would reflect one way or the other to the partners. Now, I sincerely don't think Shanobi has a typing pool. I know that at my firm I've never hired a secretary. Every lawyer who comes there, I am interested in typing speed. The same way that space was wiped out. There will be things that we do today that we will never do 5 years from now. There are things that are gone because of AI. But there will be new questions that emerge. There will be new issues, new scenarios. And so our cognitive ability, our creativity in thinking solutions. Last week I believe that a question arose and the court in New York ruled on it in the Southern District of New York. Is AI evidence admissible? No, the question was, is information generated by AI privileged? Because what I tell a client in an email is covered by privilege. You can never force me to say, you wrote to your client an email saying, no. You can't. Even if the email, I will say, my lord, the email exists, it is privileged. And that's it. But if I use AI to generate the document, is it privileged? That's a new question. And when people have said the debate along this has always been, does it make sense to go to law school? And I argue that it does. Because the questions we will deal with will be far more complex than we are dealing with today. And the causes of action will change. And so on. I could go on forever, but I think I will pause at that. I hope I have been of some use.
For those who don't know what privilege is, what you tell your lawyer, you can't tell other people. That is privilege. So please tell your lawyers things. Some people make the mistake of telling witch doctors. The witch doctor's information is not privileged, but the lawyer is very privileged. Alfred, over to you.
Yeah, thank you.
There's no privilege there.
There's no privilege there. That's true.
I've been really well answered. And I believe even theory has adapted to AI. Recently, I saw Caroline Ralina Kaza, where she had learned courses for all the AI tools, like from ChatGPT, and also the tools now we use ChatGPT. I was challenged. So even the scenarios are adopting, so it's not only the lawyers alone. But now with all that said, regarding how AI is addressing lawyers, then one wonders what will make English human about that question as advocates, and maybe finally now that we are actually, I just shifting to where I did talking about the post-industrial revolution. When person talks about post-industrial revolution, what does it mean? What is it about? In simple language, not AI language, but human language. What does it mean? Thank you.
So Alfred, brilliant questions. Let's close out on here and then come back for our agenda. I think that the most valuable thing that a lawyer will have in the age of AI, there are two valuable things. One is thinking deeply, and two will be empathy, that human element. How you decide which case to take on, because work will be simplified, but how you decide which case to take on, how you argue the case is another matter, but what drives you as a lawyer? At the end of the day, is it money? Is it fame? Is it... Because usually we answer that question later in life. I think now we'll be forced to answer it earlier in life, right? Because early in life, really you are just making ends meet. You're taking on everything because you need to cut your teeth, you need to learn, you need to grow. As you grow older, you realize, I don't have the passion for this anymore. Now I think we'll have to make that decision faster. But also the ability to think deeply, because the questions will be really complicated. I have answered certain questions for clients in the AI space, and you think to yourself, dear God, what does this mean? And that's just going to increase at a much higher scale. When you're drafting a contract involving the use of robots, which by the way happened to me in 2019, we were preparing for the Africa Blockchain Conference, 2019, about 11:30 in the night. Hanson Robotics, the company that gave us, or gave the world Sophia the robot, who were bringing Sophia here, and they sent us the contracts. My colleagues sent me and said, cancel, review, Hampson is waiting. They are on American time, so 11 p.m. was their morning. And I opened the contract, and you know that opening paragraph that says this contract for the sale of a house made this 21st day of February 2026, by and between. It said this contract for the services of a robot called Sophia. And I remember it hit me. I fell back in my chair and thought to myself, dear God, how do you allocate risk in a contract for a robot? Think about it. Because we all know if you're doing a sale agreement for a house, the vendor warrants that they have good title. They will hand over vacant possession. They will, because that's risk allocation, right? Now, if you're doing the contract for a robot, that if it refuses to speak, that was 2019. Today, and think about COVID, Alfred. One of the little known secrets is that the Congo Basin, here, between Uganda and Congo, those Congo forests, so that's like is, I think, the second largest, if not, yes, I think second to the Amazon, largest repository of pathogens. Do you know what that means?
No.
That we treat Ebola well, better than any country in the world, by the way, including the mighty America and China. Because when we got an Ebola crisis, we had no one to help us, so we figured it out. AI is growing very fast, but so is synthetic biology. And what COVID proves to us is that you do not have forever to respond. The legal questions that will arise in that world will require really deep critical analysis. And that is high value work for the lawyer who is prepared. So I think there is hope. But now let's talk about for our agenda. So think of, the world changes in leaps. Okay? If you think of a day, if you think of a year, it has seasons. Winter, summer, autumn, spring. Of course here we have hot and cold, which you can experience on the same day. But let's assume that we are thinking in terms of winter, summer, spring, and autumn. And these leaps are what you would refer to as revolutions. So the first revolution gave us the steam engine. and that enabled mechanization of production. Mechanization of production accelerated as we produce things that we sell, and really meant that there was a leap in commerce and society advanced faster. The second wave gave us electricity. The steam engine, by the way, is what leads us to cars and leads to the end of horses. The second wave gives us electricity, which leads us to mass manufacturing. And mass manufacturing means that we can trade in larger volumes across borders, and again, the economy grows and you are fine. The third revolution automated a lot of that and gave us computers and the internet. The internet liberalized information. The second revolution liberalized labor. So the first revolution liberalized production. The second revolution, labor. The third revolution liberalized information. That those of us who went to school last century used to write, I love this example, we used to write letters. When you were in school, I was in boarding school for my life, so you used to write, Dear Joy. You catch my drift.
You can't just say I.
When I last no. First of all, you saved up money and you bought a writing pad. You understand, in holidays you stocked up on the writing pads. They had flowers in them. And then you wrote nice, lovely, lyrical material. At the bottom, on the left, you wrote dedication. When I see you smile. Bye. Then you wrote, let's see another one.
Clearly a sinner saved by grace.
Clearly. You know, and then you waited. And then you waited for a long time for the letter to go across. I was library prefect in Kira College last century. I went to Kira College and during lunch, during meals, especially lunch, you would receive letters, and as library prefect, you would read letters. My friend, people would wait with bated breath. It would take at least a month for communication between. Now, that communication is there and very blissfully attached. That's what the internet did, right? It liberalized information. But with that came a lot of growth in terms of everything we do. You can find anything. I keep saying for the world's biggest university is free, doesn't charge tuition for YouTube. You see, and that means that you can learn anything from any university in the world if you're committed. The fourth industrial revolution takes that and extrapolates it. It gives us 8 to 9 technologies depending on who you ask, and what it does is that it changes how we interact, the fusion of man and machine, how we interact with machines and how we relate with them. We're talking about AI. What it really is doing is extrapolating how fast the brain can think. If you think about artificial intelligence, it's really nothing more than a combination of the work of many human brains. Because to train AI, you need data. That data was generated by somebody who had natural intelligence. So if I say, write me a poem in the style of William Shakespeare, I just borrowed Shakespeare's brain. If I say, write me a poem in the style of William Shakespeare, but please give it the tone of Olarotunu, and put a transposition with a translation of a quote from Luo. For me to be able to achieve that objective, I would need work from Olarotunu. I would need a Luo person to translate. I would need to read some Shakespeare, put all of that together, and then apply my natural intelligence to weave it together nice and neat. Yeah, I can do that in seconds. But the foundation is natural intelligence. So it is changing how we interact with machines. And the technologies we're talking about here are blockchain, which solves trust. So we are now solving different problems from access. So blockchain, what it does is to solve the trust question. And I'm going to try and simplify blockchain in 1 minute. It is this. If I write an email to Elison, okay, he receives it. If he says, if Alfred lands on this, I'm in trouble, and he deletes it, he hasn't solved the problem because I still have the email. I can send it to Mercy. That is what in technical terms is called a double spend. that I can use something twice. The double spend is also why it is easy to chukula. The underlying problem is trust. That if I write an email to Elison, I must be able to say, I wrote the email and I cannot change it. Because if I copy, paste, edit, and send, I say, no, this is the email, we now have to argue. Which of these two versions is correct? You've heard of in our profession, there used to be a problem where people would edit judgments and give you a wrong precedent. And then you're saying, but my lord, I was in court once before Justice Mulu, and we were arguing about what a judge said or didn't say. And I said, my lord, I happen to have this. He said, no. I said, counsel, I don't want a copy from either of you. Let me find it on you. That's a trust problem. What blockchain does is it says you put data on a system, everybody with access to that system knows you've put it there in real time, and you cannot change it. And the best example of a blockchain, I'll give you two examples. One, the land registry. If you think about the torrent system, the way titles are organized, that you have 25 titles making one folio, 25 folios making one. If I go and forge a white page, we have a really big problem. If I forge a duplicate, we have a white page to authenticate. If I forge a white page, which is a piece of manila paper that has value because the registrar sealed it and said it has value, there's a bigger problem. If this title is on the blockchain, at least for now, it is immutable, meaning you can't edit it because of the level of encryption. You will need 51% of the computer's access to that network to change that entry. So think about a spreadsheet with numbers, and 100 people have access to the spreadsheet, and every time you move one number, everybody's spreadsheet gets updated. You need to update 100 spreadsheets to change that one number. Do that at scale with computers across the world. That is blockchain. Now, that is what the fourth revolution is about. It's solving problems between us and machines that we usually would struggle to solve in ways that are much faster, more solid. If you think about robotics, I think that one is quite obvious. Tasks that were being done by man are now being done by machines. In some places in China, you go to a hotel, and you will live in that hotel and hardly ever speak to anyone. Why? Because when you want room service, you call and the machine will answer, you take your order, and the robot will bring your order and go away. Those will be, if you think about Amazon, the only way Amazon is able to work at scale now is because there are massive warehouses where there are robots packing things and moving them across the place. Now it's easy to see, those things are for America. There is a Ugandan who teaches people how to build robots. In fact, for him, he said, me, my life is to teach children how to build robots. So it's only a matter of time. If you think about 5G, which is the other one, it is basically internet at much, much faster speeds. It shows velocity, volume, and what's the third V? So you have, in terms of how fast and how much you can move. If you get a movie in 4K Ultra, which is basically very, very high quality, that if we see Elison's hair on the screen, we can see it the way it is naturally. That high resolution. Because it's dense, it has a lot of pixels, it is heavy to download. On current internet speeds, it could take forever. On 5G, it's seconds. So you can do a lot more, much faster. And these are the technology. So really, Alfred, in terms of why are you saying, how can we leverage these technologies to improve our lives? And for us as lawyers, what are the legal questions that arise? Of course, it's big data, which again is a statement, because all these technologies depend on one thing: data. AI is about data. Robots are basically complex mathematical equations being executed by man, right? All of that is data, and then you have the infrastructure on which they're built, and then you have, so from a lawyer's perspective, you have the work that goes into acquiring that infrastructure, securing it, building it. You have work concerning the effect of these technologies, what they can do. How do you buy these technologies? How do you write the contracts? If I'm buying an AI system and I want a contract that will protect me as the user, what do I do? You see, so I hope that gives you an insight of what we really mean when we talk about 4IR.
Thank you very much. If you're just joining us, welcome to the Judicial Service Conversations. We are having a fantastic conversation with Mr. Robert Kirunda, reimagining the future of legal practice, and we've had all manner of things. We have a number of questions coming in, and please continue to send them. We shall throw them to Robert very shortly. Allow me to hand over to Joy E. Joy, over to you.
Thank you very much, and thank you to you that is listening in tonight as we talk about reimagining the future of legal practice together with Mr. Robert Kirunda. And there's been lots of worries. I think the conversation, once we set out the flyer and also in the comment section, you can see there's a lot of tension. People are afraid that AI is actually here for their jobs. But I want to believe that if you've been listening, then I think in between there you've gotten your answer. And then I think the two bits that you highlighted. So if you are there and terrified and thinking, do I have a future? You need to work on your frontal lobe. I believe that is your cognitive, what did you call it? Yes. Your capacity to be able to think and think deeply. And then of course remember that what separates you from these machines is the ability to be human, and so you need to have some empathy. So I think if we work around that and try to add value to ourselves, then we still have a future. Now, onto the questions. I think I just wanted to touch briefly on the comments. There's Janice Chakundwa. She's saying very true. Many courts here in DC have begun using AI not to replace justice, but to improve efficiency, reduce delays, and help ensure that decisions are guided by evidence and consistency, while the final judgment still remains in human hands. And she adds that in many developed countries, AI, including tools like ChatGPT, is already woven into daily life. As banking, healthcare, transport, and public services are integrated, so we really need separate platforms. Uganda will get there, but it takes time, infrastructure, and policy. And she says she thinks Tech Crooks, I don't know if I'm pronouncing this well, of this presentation is how quickly and responsibly we build through AI integration into everyday life. I think I tend to agree. So okay, saying the right man to address us on the future of legal practice, the radical old bar. A lawyer is saying, should there be regulations requiring lawyers to disclose AI usage in court filings or client advice? Oh well, and several people. We just have a lot of engagement online, just to say that we are happy to have you. Now, there's a question that came in from Jamie Steele. It says, if the future of justice won't design itself, how do AI-driven courts and tech reforms grow without undermining due process, judicial independence, and the protection of lawful advocacy? So I just have three of them that are pushed to you. So I think I will do a one at a time, and then if you could start with this. Over to you.
So, first of all, many thanks to our audience for the very kind thoughts and comments that you've shared. But that question that Janice asks a fundamental question, and while it can have many answers, I will just start with this. If you come across AI discourse in the AI space, there is something that has now become, I think, default, which is the human in the loop. The way to achieve the objective that Janice is talking about is keep the human in the loop. We all agree that AI tools are efficient, they are useful, they can improve a lot of work incredibly. And I know from what I have followed up on WhatsApp and industrial code, for instance, that even those, such as in our course, talking about these tools, are saying they will always need to be mediated by a human who understands what's happening. Now, I think the answer is more nuanced than that. You don't just need a human in the loop. You need a skilled human in the loop. a human who understands that which was and that which is needed. There's a trap there. How do you guard against replacing one form of bias with another? Because you can say we are using the human in the loop to avoid the bias of the machine and instead create a god called Elison, who sits there and makes a judgment call that has grave consequences, and there's no one coming back to them accountable. And these are the riddles of the AI age. How do you hold these humans in the loop accountable? The question policy, ethical, and regulatory positions on the use of AI is precisely that there must always be that individual who is accountable for what comes out of these machines and for the use of these tools. Because right now, every time we are all frustrated with ICMIS, nobody has asked, but if my case is dismissed because it went in the wrong space on ICMIS. Have you had that experience where you file a document, or where the other side files a document in other documents? My friend, when a warrant of arrest depends on whether or not there's an affidavit in reply, that's a serious issue. Because the judge is saying the application is not opposed. And you're saying, no, my lord, I filed the affidavit. Someone went into the court system and moved it from where I put it and put it in other documents. And the judge cannot find the affidavit. And he signs a warrant. Somebody should pay for that. But none of us is asking who.
Who is Mr. Ikmis?
Who is Mr. Ikmis? This, is it SJ?
We shall bring him to the Judicial Service Conversations very soon.
You see what I mean? Now that's a very simplified example of why you need a skilled human in the loop and why you need rules to guard against excessive manipulation. But I bear the view that, one, it is the role of lawyers to solve these riddles. Two, and that is work. The future of our profession, that is work. Somebody will get paid to answer that question. I hope it will be me. But if it isn't, somebody will get paid to answer that question. And what we also need to encourage, and if there are any policy makers on the platform, any people in the judiciary, I would urge collaborative construction of these tools. Let's not do this thing where the judiciary builds a system for lawyers to use and lawyers have no input. At the same time, let us pay actual value for these tools. I know law firms that are building AI tools and they are paying for them heavily. So if this country is going to invest in tools for us, let us participate in that process because it helps all of us. The other problem in the AI space, which I think Janice is collateral to her question, is opaqueness. And that's what we must solve. That we must be able to see behind the curtain what is going on. That's how we can raise questions when we need to raise them. But for that, we need to skill ourselves to be able to raise the right questions. Thank you.
Perfect. Thank you very much. Janice, I hope you've been ably responded to. So the next question is coming in from Anthony Natif. It's a question on corporate finance and the role of foreign capital in our economy. So he's saying, how can we make such capital feel safe? Over to you, sir.
Mr. Natif, one of our colleagues here said your question is billable. So thankfully, now that you have disclosed your identity, I am going to answer the question, but I also happen to know that our finance person is on the call. So please check your email before 9 a.m. There will be a please find attached. How do we make this capital flow? I think we start where this conversation started.
And the invoice will be IFRIS.
Certainly. We start where this conversation started. We need to make sure that Uganda is safe and investable. Believe me when I tell you, there is so much truth in that old cliche. Money hates noise. Of any kind. If we want to attract capital here, we must solve the simple basic issues. We need to make sure that Uganda is safe and secure. We need to, and that's not a political statement, that's a statement of fact. We need to make sure that our courts work. That's why some of us have gone into arbitration. We need to make sure that rules mean something. They are not suggestions, they are commands. We need to make sure that there is clarity. At the end of the day, every client in the world is looking for two things. Every funder in the world, in fact, let me modify what I was going to say by saying every funder, not just every client, every funder is looking for three things. Can I trust you? Can I be certain? Can I be confident in your stability? So let me explain. In Silicon Valley, Natif being a person who has played this game, in Silicon Valley in California, there is a road called Sand Hill Road. Somewhere on Sand Hill Road, in a space much smaller than Nakasero. In fact, the distance is maybe, if you compare from the Stanbic roundabout, Crescent Towers, up to Imperial Royal, no, up to maybe Kampala Club, and back downwards, right? By Pastoral and whatnot. A space that big controls over $3 trillion. Controls over $3 trillion of capital. That is...
Isn't that more than the GDP of Africa?
No, certainly. That is where the biggest venture capital funds in the world are located. People there invest on the basis of a pitch deck. 14 slides. The standard pitch deck is 14 slides. 14. And they will give you millions of dollars. And they invest knowing 9 out of 10 of the bets I'm going to place will fail. But that one is a Facebook, is a Twitter, is the so-called moonshot, which will bring back returns in the billions. Why does this system work? 3 things. 1, they know that if you fool around with my money, I will go to the courts, and the courts will call you to order. In Uganda, it will take you 4 years in the High Court, if you are lucky. Hopefully COVID doesn't hit. 5 years in the Court of Appeal. I mean, I got a schedule for next week's panels in the Court of Appeal. And I saw an appeal that we are handling that was filed in 2016. 10 years ago. The client doesn't even live in Uganda anymore. So I text him and say, this matter. And he calls me and says, which one is that? That's just Court of Appeal. Now there's a chance we are going one more ladder before we come back. I have just participated in mediating a settlement of a 21-year-old dispute at the Supreme Court on a PO. 21 years on consolidation. Should we consolidate or not? Then you go back and now start the main trial. Then go back again. It doesn't work. Investors need to know, and a lawyer said this to me in 2017 in London. I went to do business development, and I'm sitting in one of the biggest firms in London, and I said to a lawyer, I'm going to be straight with you. You British people are polite, me, I am not. I don't have the time to be polite. Your time is valuable, so I'll cut to the chase. I have mouths to feed, employees to pay. Give me a deal so I can make money. And he looked at me and smiled and said, you're a very interesting young man. I want to give you a deal, but I'm going to ask you 2 questions. One, why is it you're a private citizen sitting here asking me this? You're not a minister for investment, you're not the governor of the central bank, you're not minister of finance. Why isn't it your government coming to London to tell me to bring business to us? I said, look, me, I told you I have people to feed. Government has a treasury, I don't. He says, okay, guarantee me that if I come to Uganda and I do a mining deal and things go wrong, I will go to court, I'll get a judgment. I don't have to win, the judgment will be fair. If you're in my shoes, what would you have said? He said, I want you to tell me that if I go to a court, I'll get a judgment, it will be quick, it will be fair. I don't have to win. I said, my answer was, that is why we are pushing private sector-led arbitration. And he said, okay, tell me about that. And there went my chance to get a deal in mining. Natif, we must build a judicial system that works. Now, as to whether the current one is working or not, I will let you decide. But it certainly can do better. If we are being frank, it certainly can do better. Has there been improvement? Yes. Are we where we need to be? You decide. The third thing is we as people in the private sector must play our role. If you borrow people's money, pay it back. It's just good manners to do so. Right? If you do a deal with people and say, I am going to be a shareholder and I will do the following things, do those things because you made the promise. At the end of the day, we will make more money, we will attract more capital if people know, go to Uganda, do a deal, they keep their word. That is much faster than any debate we can have on interest rates. Or you see me, I want to try and avoid clever answers. You see, GDP, that stuff I left for you complicated minds to deal with. Me, I like to deal with simple things. If a client comes to me and says, should I sign this contract? And I look across the table and I say, who are you signing with? Elison Karuhanga. At the end of the day, the man who trained me, and I will give him credit, his name is Kakembo Katende, he used to ask us a question. You would sit in a boardroom and you would argue about this deal for 2 hours. And then he would say, Robert, if it was your money, would you invest it? And if you hesitated, he would say, tell the client not to invest. Because you know something that makes you unsure. So that's the way I would look at it. Thank you.
Thank you. If you're just joining us, welcome to Judicial Service Conversations. We're having Mr. Robert Kirunda reimagining the future of legal practice. I think if Robert the evangelist had met the client, if you asked him about whether he should go to court, he would have of course told him about Matthew chapter 5, verse 25. Settle matters quickly with your adversary who is taking you to court. So he would have told him, settle.
I'm sure he would have told him settle. I think we still have some more questions from the audience. Maybe we'll come back to them. I don't know how many Joy has, maybe about 3 or 4, but we'll 5. Please keep them coming in. We'll come back to them, Joy. But maybe now, very briefly, I hand over to Mercy Makabai Chemutai. Mercy, if you could just ask your questions, and then we take it from there.
Thank you, Elison. Thank you, Elison, and thank you very much, Mr. Kirunda. I'm enjoying this conversation. It's my first time to meet you, but I believe your students really do benefit greatly from being under your guidance. I'm going to take us to arbitration, which I believe is a topic you enjoy.
Yes.
Can you hear me now? apologies for that. I was not being heard. Yes, so I'm taking you to arbitration now. For those people who are studying law in law school and maybe the non-lawyers that we have in the space, what would be your high-level summary on what arbitration is and its current status in Uganda from your own observation and your experience?
I think if you're just joining us, I think what Mercy has asked is what Robert's experience is on arbitration. I think there was a break in the call, but I think that's the question. What is your experience on arbitration?
And a good understanding, a high-level understanding of arbitration.
And give us a high-level understanding of arbitration in just a few minutes. She wants a bird's eye view of arbitration. What is arbitration?
A bird's eye view of arbitration. So first of all, you're right, Mercy. This is a fantastic, an area of great interest to me. I am privileged to be one of Uganda's 2 members to the Permanent Court of Arbitration, but also locally to participate as a practitioner and as an arbitrator. In simple terms, unlike the ordinary court where you go and sit and find a judge seated on his, I'm tempted to say on his throne high and mighty, but I won't say that, seated up there administering justice, being paid by the Treasury, following a strict set of rules to arrive at a decision. Arbitration is the process where we agree, 2 parties agree, to go to an independent third party whose skill they trust, whose independence they trust, and they commit their dispute to them, committing themselves to be bound by the outcome. Such that if Elison and Alfred come to me and say, we are arguing about who owns this bottle of water, and because the bottle of water is worth 1 million shillings, I will say to Elison, what's your view? Give me your evidence. I'll say to Alfred, what's your evidence? I will render a decision. Everything I do is based on consent from the 2 of them. Number 1. So arbitration works by party autonomy. The parties are in control of the process. But once they agree on what process they want to undertake, then they are bound to that process. So they will pick the rules that will govern the dispute as opposed to a static set of rules. They will pick the decision maker as opposed to a judiciary where you go and they allocate to you a judge. They will pay for that decision. Usually what will happen is they will split the cost between them, and then they decide whoever prevails can come and recover from the other. In very simple terms. So you get to write your own rules, you pick your own judge. In fact, in some places they call it a rented judge system, where you basically pay somebody to be judge of that one dispute. They have no other judicial power outside what you've defined for them to do. What is it looking like in Uganda today? Private sector-led arbitration is growing much faster, and I think it's a very good thing. It's a very good thing because it inspires a lot more commerce, I think. It is a good thing because it creates work for lawyers, because a lawyer can play 3 roles. You can be an expert, you can be you can adjudicate a dispute as arbitrator, you can also be counsel. So if you think about any arbitration, there's 5 people earning a fee. There's 2 lawyers for the parties, there's the arbitrator, and sometimes potentially witnesses on either side who are lawyers. In a typical commercial dispute, you have 2 lawyers earning a fee. So it is growing, and by the way, it can also work public and private sector. Someone does work with government, okay, and let's imagine they built a road, or across from where we are, somebody is building a chamber for parliament, and the contract says if a dispute arises, we will go to arbitration. Even though the person funding that work and the client is Parliament of Uganda or the government of Uganda, once government agrees in that contract to go to arbitration, they can't then say we are going to court because we control the judiciary. No, they will be stuck with that clause. And in fact, Ugandan courts have, I think, settled the question. Once there is a valid binding and enforceable arbitration clause, they will send you away from the courts. And I think it's a good position. Also, arbitration, unlike the courts, will have finality much faster because, generally speaking, an arbitral decision is not appealable. There are very limited circumstances in our law where that decision can be appealed. So forget about the Supreme Court, forget about the Court of Appeal. Once you have an award, you go to the High Court to enforce. You register it, and it's enforced as a decree of the High Court. Why is that important? A dispute that would have taken 4 years in the mainstream court system can take up to a year. If you go and look at the statistics at the Center for Arbitration Dispute Resolution, I think the average time span there for disputes used to be, before it was disbanded, CADA's average time was 6 months. I have handled arbitration disputes. In one of, I participated in a dispute, $66 million worth of an award. It took us a year to get. But arguably the most complex commercial dispute I have ever handled in my career. In that dispute, I was counsel. In another dispute where I was arbitrator, the value of the subject matter was 287 billion Uganda shillings. It took us 5 months to decide. Now you can imagine how complex those cases were if you had to go to the courts and you have to schedule witnesses, and then it just so happens that when you schedule the matter, election petitions kick in. Because, for instance, the moment petitions start, I don't know when they are starting, maybe end of month or March to August, the High Court is frozen. Why? Judges are hearing petitions deciding on how people voted. But arbitration will continue. And those have the advantages. And I believe it's growing, and it's a good thing, and I hope it grows even faster. Thank you.
For those who don't know, under Ugandan law, election petitions take precedent. So if you have a criminal matter, a family matter, a divorce, a land dispute, judges assigned to election petitions, the petitions must be finished within a specific period of time, and they must start for parliamentary election petitions after the Gazette. And I think the Gazette came out. So that's why that issue arose. Mercy?
Thank you very much. Two issues arise in my mind with respect to what you just told us. This issue of enforceability of arbitration awards. This issue of enforceability of arbitration awards. I think there has been a bit of a disconnect on public interest, that exception of public interest. I think courts here in Uganda need to determine what amounts to public interest, because we have a number of people who have got international awards and come into the country and try to enforce them and get an order from court for enforcement, and courts have used that exception to avoid that enforcement. What is your opinion on that?
So just for clarity, you mean public policy as opposed to public interest? The public policy exception is one of those two very narrow exceptions under which you can set aside an arbitral award. And basically, the argument is that enforcing the award would go against what would generally be acceptable in the Ugandan context. Justice Mubiru has said the unruly... there's a very interesting word he used. But he also said that while it has no precise boundaries, there is enough scope for us to determine what is generally acceptable in Uganda's public policy. I think that as the jurisprudence grows, it's becoming even clearer. Nowhere in the world do you have a precise definition. Why? Because societies evolve. Laws change. And what is generally acceptable today might not be acceptable tomorrow. If you go back to law school first year, when we read Rex Amkeo, bride price was frowned upon, and yet many of us in this room either have charged or paid bride price. Many years after Amkeo. You see what I mean? That if you look at Alai versus Uganda, shortly after maybe 100 years ago, and you look at Amkeo, 1967, 67 to today is almost what? 70 years? 50, 60 years? Let us not good with math. We can say 25 plus. We can get there. Whatever the number is. Today. Now, the amount might differ. But the principle remains that in certain even after the Uganda Supreme Court has said dowry is unconstitutional, there will be people who, Mr. Elison Karuhanga will say, you want my daughter? There will be a kugamba obujenyi. You will bring me a Bible, and you will also bring me a cow. And people will do it.
They now call it Enkwatarugo.
Enkwatarugo. There you go.
Cash.
So the means have changed. That now in Enkwatarugo, you bring your cash. If you don't have it, there's a problem. The philosophy may not be the same. The philosophy back then might have been that I have earned the right as a parent, really for you to, and if I use the word here loosely, reward me for raising this daughter, or appreciate me for raising this daughter. Now the philosophy might be, I want to know that my daughter is safe and secure where she's going. It doesn't take her what it is. Now, think of public policy in the context of those rules that we can't define with exegetical exactitude. We cannot say with precision, this is what the rule should be. But we can all generally agree, this is wrong. Right? For example, I think one of the decisions on this point was the argument was about whether or not the person who was claiming was trying to enforce, to recover money they used to pay a bribe. And so generally speaking, we can all tend to agree that while on the street people might agree that's how these things work, the moment you enter the courts, we remind you, the rule is still that corruption is illegal. And that is public policy. So you will find that although it might seem too broad in scope, it is not too hard to discern. It is perhaps, and I see my brother Nicholas is on the call, so I cannot resist taking a swipe at him. It is what Nicholas would probably say an American judge has defined pornography to be. I may not know exactly what it is, but I know it when I see it. You see, so public policy is one of those things which you know when you see. That, surely. Yes, maybe without that bribe there would be no project. And maybe we can argue in hindsight the bribe should never have been paid. But the rule still is paying a bribe is illegal. I hope that makes some sense. Thank you.
Okay, so if you're just joining us, welcome to Judicial Service Conversations. I think that particular American judge, I don't know which judges Nicholas knows in America, but that judge who keeps asking to see pornography so that he can say on the record, I saw it, and it is pornography. I'm not sure. I think let's take one more question from you, Mercy. We are going to be closing this space. We had said 9. I don't know if Mr. Kirunda, you can add us another 15 or 20 minutes such that we take a few questions from the audience, and then I'll have one traditional question that we throw here, and then we'll... Okay. So Mercy, please, a question. Keep it brief.
Mr. Kirunda, there's this issue of case backlog here in Uganda. So we have a lot of people now obviously resorting to commercial arbitration for most of these contracts that we have, maybe where we have a Chinese supplier with a Ugandan person, and then you have a scenario where they're insisting that the arbitration should take place outside of Uganda. And a lot of people, even in East Africa, prefer to now go to Rwanda, for instance. That's a trend that we are seeing in some of these contracts. What do you think the Ugandan arbitration system lacks that's not building more credibility and confidence for most of these investors to prefer to use Ugandan arbitrators and the Ugandan law and the system to have their disputes resolved locally rather than prefer to go outside Uganda for contracts actually implemented and done here in Uganda?
That's a fantastic question, Mercy. And it raises a number of things. But first, let's recognize that arbitration institution is just growing. the Arbitration and Conciliation Act of 2000, the reform in 2000 was really important because for a long time the problems of the courts were also the problems of arbitration. Even after that, uptake was low, I think because there was fatigue from previous experience. Some things have changed, which I think are good. The first is that you now have you have a higher number of practitioners paying attention to it, to arbitration. I have to shout out to my dear friend and our colleague David Kagwa, who has been one of the champions in training more arbitrators and practitioners in Uganda through the work of the Chartered Institute of Arbitrators. One of the things that needs to improve drastically is improving Uganda as a seat. And that raises a number of layers. One, practitioners and those who are coming out of law school need to really appreciate the impact of choice of law and choice of seat of arbitration. If you choose Rwanda as the seat of arbitration, you are saying that should a procedural question arise that needs the courts, that question will go to the court in Rwanda. If you choose London as the seat and you want an injunction, ordinarily you should first go to London. If you want to set aside that award, you should go to the London courts. Now, any Ugandan businessman today who says, I think that one of the arguments I have heard, true or false, about Rwanda being a preferred seat is things work there. They move quickly, which means that we need to fix Uganda for things to move quickly. I have said it publicly, and I will say it again on this space. We need to amend the Court of Appeal rules to provide expressly, because clearly judicial precedent is not doing what it should do. We need to put in the Court of Appeal rules that the Court of Appeal has no jurisdiction in arbitration matters, full stop. Such that anyone who gets an award against them, if they didn't reserve the right of appeal, they should not spend judicial resources going to the Court of Appeal. This point has been settled by precedent from the Supreme Court downwards. We still litigate arbitration in the Court of Appeal. And I have said to the judges there who are in charge of reforming the rules that, in my humble opinion, we need a rule there that means that we close that door, if need be, permanently. Because we must make this thing work. It moves faster. If you want to understand the cost of judicial challenges, go and compute how much capital is stuck in the commercial court today because of case backlog. Then you will understand that, you see, I have serious issues with penal regulator. Indeed, I litigated the petition, which is now in the Supreme Court, saying this 30% rule is bad. But I hear the argument on the other side, which is, we lent you people's money. That when a bank lends Alfred money, they're lending depositors money. And they must account for it. And if they don't recover that money in 30 days to a year, they must put up capital to cover for your refusal to pay. That's not fair. And I understand that. But the solution, in my view, is judges deciding matters faster. So, to answer your question, if we want to be a desirable seat, number one, we must make the system work. We must, because if I go to London and I get an award in 1 year, and 6 years later I am still arguing applications on whether or not, let me see, what are we arguing about now in that particular case? We are arguing about whether or not an appeal against a refusal to grant leave to appeal is appealable in the Supreme Court. What does that have to do with the date? So I understand the client who says, you know what? And in that case, I can tell you, my client, I said I will never do a deal in Uganda again. The real victim there is not me or the person who refused to. It is the person who would have benefited from the next project they lent. That is the actual cost of a dysfunctional judiciary. That when an investor says, I will not do business in Uganda, for whatever it's worth, this is a $2 billion fund, the person you are punishing is the villager who would have been on a coffee farm financed by this investor. Because the court entertained an appeal on whether or not to grant leave to appeal a decision on interim measures in arbitration. What does that have to do with the dispute? So So I think the starting point is amend the Court of Appeal rules to say the Court of Appeal has no jurisdiction. Do the same thing to Supreme Court Appeal, Supreme Court rules. Then let lawyers pay enough attention to the implications of a seat, choice of seat. Because if you see, the problem is that many times we think of these things at the point of the fight. The fight doesn't happen when Elison fails to pay. Now, for clarity, before Elison, soon for information, Elison is...
I'm struggling to pay.
He's neither indebted nor a man of straw. And he's a man of good manners. He's a Lannister. He keeps his word. That I can say without fear of contradiction. Now, the point I was developing is that, you see, the dispute happens the day we sign the contract, not the day the default happens. So before you sign that contract, think about what happens if things go wrong. Donald Trump, in his book, The Art of the Deal, writes a very simple principle. He says, protect the downside, the upside will take care of itself. I keep telling people when they come to me for advice that borrowers read the contract from beginning. Usually it should be to the end, but they tend to stop where the economic terms stop. When the dispute happens, lawyers, at least me, I read the contract from the end to the beginning, because I'm saying, okay, now clearly this is a fight. What is the dispute resolution mechanism? Arbitration. Ah, good. This one will be quick. What is the governing law? The laws of China. We need Chinese counsel. You see, so think about this clause at the point when you're signing the contract. If a dispute happens and I want an interim measure, which court do I want to go to? Do I want to go to a Rwandan court? Do I want to go to a Ugandan court? Do I want to go to an English court? Will I get a visa? Thank God for online appearance now. But that used to be a consideration, that if I am choosing a seat of arbitration, for me I would say, is this a country I can enter and exit easily? Because you know our passports, they have their weight, but if you choose AAA arbitration in New York, you will have to deposit $15,000 in addition to a visa fee, and you can only enter once for 3 months. So those are the practical things we need to think about. Thank you.
Okay, thank you. If you're just joining us, welcome to the Judicial Service Conversations. We are soon winding up. You know, there was a lot of legalese about the about the sort of applications you have in the court. But if you want to understand it properly, just think about a tribe in Congo called the Azande. I think this is what Robert is saying. In Congo, they resolve the dispute using a chicken. A medicine man, and you take a white chicken to the medicine man. The ancestors possess the chicken, and the medicine man strangles it. If it dies, the accused is, or the plaintiff has won. If it lives, so it depends on how much the medicine man strangles the chicken. So what he's saying is that the problem with our court system on the doctrine of precedent is that the judge dresses in some funny clothes, reduces the thing to an issue that nobody can understand, which is the chicken, and then claims he's relying on the ancestors, which is what we call the doctrine of precedent. So if you want to understand our law properly, the judge simply strangles the chicken, depending on how he sees which side is correct or wrong. He either strangles it to death or he strangles it to life. Joy. I hope I've summarized that whole discussion about stay of execution, appeal, application, and this is what we call, for those who are just joining us, this is what we call introduction to law. Now, Joy maybe has 1 or 2 questions from the audience, and then I will ask a question about mission-based justice, and then we will be closing the space. Joy.
Yeah, sure. We'll be strangling the chickens, but thank you for staying with us on this amazing conversation. We're reimagining the future of legal practice together with Mr. Robert Kirunda, and we want to appreciate everybody that has that started with us at 7 and is still on. Now, there's a question that came in from Seguya Enoch. He says in a jurisdiction like Uganda, where judicial independence is already under strain, how do we firewall due process when AI starts predicting bail outcomes, sentencing patterns, or even flagging advocacy as disruptive without handling authoritarian regimes the perfect automation of control? Over to you.
Maybe just before you come on, I've seen a comment here which I think needs some clarification on. And this is a comment coming from somebody who is calling himself Bomboclat. And he says it is the Starks that keep their word. The Lannisters are betrayers. But anyhow, I think Starks or Lannisters are... but the Lannister pays his debts. The Lannister pays his debts. But also, I'm seeing a lot of commentary coming in, and maybe we can handle a lot of them together. I am seeing comments coming in from someone called Lillian. What role should lawyers play in shaping AI? I'm seeing, but I think you've answered that. Will AI make lawyers more productive overall? I think you've answered that. I'm seeing someone saying, how can established lawyers adapt AI to avoid obsolescence, such as through continuous learning? I think you've answered many of the AI questions, but I think the ultimate, I think that question from Seguia also about automation and bail, I can assure you that a lot of the bail jurisprudence, for sure, at least the ones which are coming out now, is definitely not AI generated. But maybe over to you.
So that's a fantastic question. And Elison is dead on the money on this one. Also, many thanks to the person who corrected us on that reference about the Starks and the Lannisters. Indeed, Reina is right, and that's what I was trying to say. The Lannisters pay their debts. I was trying to say Elison pays his debts, but also he's not a man of straw. But indeed, the Starks keep their words. But thank you for the correction. These references are important. I come from a literature background, and so if I got anything wrong in the literary context, my father would be very upset with me. But back to the question about prediction. I think that predictive AI will take a long time to have. Not long. In the AI terms, you can never say anything will take long. But I think it will take a while for us to get to the point where... You see, there are two things. One, there is predictive ability. I can use it to predict and say that if I go before Justice Karuhanga, what is the likely outcome? And that will benefit me. But will Justice Karuhanga use the tool to say which way should I rule? I think not. I think our social fabric is not constructed like that, just generally. And I agree with Elison. The decisions we are seeing on bail today, in any type of case, in any type of matter, really are not AI generated. And knowing, and this is, I mean to cast no aspersions on the current men and women who serve in Uganda's judiciary, but knowing the construction judiciary today, I don't think they will be inclined to go down that route anytime soon. That's also because I think that if we solve the overall backlog question, we will go back to the fundamentals. Now, I think it's easy to think about bail in the context of the cases we see in the media today. Many of those tend to be political cases. But I would suggest that as we discuss bail and AI, we think about non-political cases. If you go to the criminal division of the High Court on any day, and I have spoken to some of the judges and justices that work there, the one thing I hear in common with all of them, and I am talking about non-political cases here, those ones, they sometimes will open up to you and tell you about. I am in the habit of never discussing a political case with any judicial officer, judge or not. They will tell you that, and you can read in the tone, that they approach these cases from a human perspective. They look at this child and say, but this 17-year-old, how do I deal with it? In fact, they actually look at these cases from a perspective of, is it fair? You read the Court of Appeal decisions. There was a decision, I think the lead judgment was by Justice Egonantene, that one I will mention. if I recall correctly. And in that case, the court began by apologizing because the person had spent so much time on bail that by the time the case came to court, in fact, I think it was an appeal. He had spent so much time on.
Yes.
And when they appeal said, when they went for a session, he said, it was a revision. I said, you know what? It's okay. Let me serve my sentence. It's okay. And when you read the judgment where the court is saying, we are sorry, this should never have happened. This was abuse of court process. Then you see that those are not the kinds of people who will say, AI tell me which way should I rule. And I think that's a very good thing. I think that we should salute the men and women on the bench who are doing that with a human conscience to put, because justice, I learned this from my colleague, Professor Mbazira, in the public interest, one of, I genuinely believe Africa's leading voice on public interest litigation, in the scholarly and also an active practitioner. And he taught me a valuable lesson. And he said, Robert, every case you ever handle has a human face. And as long as we keep reminding our judges of that, I think that we will be on the right footing. And lastly, on this point, Joy, let's not forget that as AI develops, AI will be context-based. It will be nuanced. And so if we maintain that human element, and if I emphasize anything today, it will be emphasizing that in our use of AI, let's not lose that human touch as we use these tools. If we keep going back to the court and saying, my Lord, this is a 12-year-old child, that's just good advocacy. And that's something AI will never be able to do. If we keep going back and saying, he may have murdered, but even the thief on the cross got a hearing. You see, if we just stick to those tenets of justice that keep it human, that keep it raw, that remind the courts that these courts exist to exercise the norms, the wills, and the aspirations of the people. If we litigate and remind the courts that is not Ugandan, then I think we will achieve that objective.
Maybe just to point out that in that famous story, whereas the man on the left got a fair hearing, the man in the middle was the subject of fabricated testimony, a biased court moved by the witnesses couldn't bring their testimonies to agree, and he was hanged nonetheless.
But you see, Elison, right there is exactly how we must look at the Ugandan courts. That we can have and the result of this dichotomy is the man on the right, where people say, "Don't tell me about that business," and that's the extreme we must avoid. And there is this famous preacher who then preaches the best Islamists they've ever had, and he says, think of the thief on the cross. He gets to heaven, and they ask him, we don't see your name. Did you ever confess Christ? He says, no. Yeah. How are you here? I don't know. What do you mean? The angel is confused, gets the supervisor, says, So just a few questions. Doctrine of baptism, I've never heard of it in my life. Salvation, never heard of it. Scripture, yeah. So, how are you here? And says, the man on the middle cross said I should come. The point I'm making is that you can have three outcomes. You can have a judicial system where everybody, even a thief on a cross, gets a fair hearing.
Yes.
The promise of the Constitution is independent and transparent. Impartial, an impartial hearing before an independent and transparent
tribunal.
That's the promise of the Constitution. And we need to keep hammering that down. If you don't do that, and you end up with this man who is a result of a kangaroo process, the result is the guy on the right says, the hell with these people, and what kind of messiah are you? The day people scorn the courts, I fear that the outcome will be tragic.
Thank you. The day people scorn the courts, the outcome will be tragic. And as you've heard, the philosophical depth as you've had the philosophical depth of the conversation. Now, that brings me now to what is usually our traditional closing question. I had a number of questions for you, but I'll just run to this one. The day people scorn the courts is the day the justice system, is the day society will be in trouble. We have a massive backlog problem in this country. Today as we speak, we were told up to 14 trillion shillings is held up in the judiciary with 1.2 commercial court. The annual at the opening of the new law year by the Land Attorney General of Uganda. Although one of my learned friends was here last week saying that he has some skepticism on those figures, but nonetheless they are crazy figures. We have the average, actually not even average, a Ugandan who is currently remanded on a capital offense with no chance of bail. The fastest his trial or her trial can be in this country today is 2 years. 2 years on pre-trial remand is considered speed. In fact, it's considered unfair. Averagely, Ugandans are spending 5 to 7 years on remand in jail. A land dispute is taking between 7 to 10 years. We have a crisis of backlog. It is a crisis of justice, and in my opinion, backlog is the tyranny of our time. My question to you is not so much about the diagnosis of the problem, but what is the prescription of the solution? At these conversations, we have said for the better part of 1 year that we need to invoke Article 142.2 of the Constitution and bring in mission-based judges. There are those who have come on these conversations and agreed with us. There are those, including a retired Chief Justice, who have come on these conversations and not agreed with us. What is your view on the solution to backlog? And do you think that mission-based justice has a place in this solution?
So, Elison, I must start by commending you for leading this charge and raising this issue. But I want to say two things as foundation before I start on the question. I happen to have carried with me a constitution, and I want to read out Article 28, Clause 1. For a simple reason. I think that this is a question of conscience, where we have reached. It must become, my view is that we need to look at this as a question of conscience, in the national conscience. In determination of civil rights and obligations, or any criminal charge, a person shall, we can all agree that's mandatory, be entitled at the mercy of no one to a fair, speedy, and public hearing. Those three things. The hearing should, first of all, you must have a hearing. That hearing must be fair, it must be speedy, it must be public. Those are not, Aaron Kiza said this and maybe we didn't like his tone, but I think he was right. Those words, the negotiation on them ended on 10 October 1995. If we can agree that those words are not negotiable, that
Resolved by the Eli Karuhangas.
resolved by the Eli Karuhangas. You see, by the way, I was once in court. Now I must tell you a story, really. I think you and I were in court that day in a bail application argued by the Honorable Eli Karuhanga, Joseph Matsiko, and Sam Mayanja. The year was 2009, 2010 in Nakawa. And while Mr. Masiko was making a really eloquent argument, Eli Karuhanga couldn't resist the urge. He chipped in and said, when he said the constitution, Eli Karuhanga said, the one we wrote. I have to say, no matter what you thought of the man, you couldn't take that away from him. And every now and then I like going back to read the Hansard. This document wasn't by fantastic. The amount of thought and debate that went into the wording that we call Uganda's constitution, I think deserves credit. And I salute those who participated in writing it. Many of whom are still alive. Some who have passed on, may their memory live long with us. So I want to start by saying those words, if we can agree as a matter of national conscience, that those words, the negotiation closed. This trial must be before an independent and impartial court or tribunal established by law, right? Why I say it's a matter of conscience is because we are all one bad decision away from needing a trial. The mistake most of us make is assuming it must be your bad decision. It doesn't have to be. That is the point of provocation. That some guy insults you and you throw a punch. Now, we can debate who made the bad decision. But society will look at you and say you ought to have known better. After all, Joe, you're a lawyer. Surely you know better. Now your crime is being a lawyer. If you read Jamwa versus Uganda, if you read Uganda versus Jamwa, the High Court decision, Justice Katu says, nevertheless, you were an intelligent man. You should have known better. That is in a judgment. Go to jail. Jamwa's crime, in my view, was being intelligent. Now we can debate that. We can debate that till the chicken come home. But the point is this.
Upheld by the Supreme Court.
There you go. But you see, the point here is, if we all agree that you are one bad decision away from needing a trial, my friend.
Or one misunderstanding.
It will keep you humble, firstly, but secondly, you will understand why those who agitate for a speedy hearing. I was once training police officers and I said, no, this thing of 48-hour rule, it is bad. I said, you people, you are saying remove 48 hours because you are the one enforcing it. You are the one who wants to live with it today. The day you are the one who needs those 48 hours. My friend. So I say all of that to say, can we agree, surely, that as a country, backlog is a crisis of conscience? There are things...
Amen.
There are things that we should be able to be unanimous about and say, we need to get to a point where, if not for my sake, for my neighbor's sake, it cannot be that the first day I get to go to a court, which won't be the last, to present my evidence, will be 2 years after I am locked up. The child I left at home, the orphan I feed, what role do they have in the crime I am accused of? That is the cost of backlog. And if we can, you see, it is a person who isn't moved by money. I have colleagues at the law school who don't really care about money. It does not move them. I don't understand them, but they are there, and I respect them. For them, money...
I also don't understand them.
But you see, interestingly, they are all in the constitutional space. They understood that the things that move society have little to do with the economic quotient. So we can trivialize backlog because it is measured in terms of 14 trillion. In my days when I used to be in the media, I used to say that we need to get MPs to understand the weight of the budget. We need to cut 1 trillion pieces of paper, 1 trillion shillings, and show them this is what 1 trillion looks like. So when you say 90 trillion, this is how much money you're giving out. Then maybe they will think about the budget differently. But I left my media days are behind me, so I will move on from that. The cost of backlog is unjustifiable. That brings me to my answer to your question. If we agree on that point, then we must agree that where we are now, we can't stay much longer. I know that there are two schools of thought on mission-based judges. The first school of thought, and I think steeped in the Kabumba decision, in the Dr. Businja Kabumba, my friend and colleague at the law school, shout out to him. He did a good thing to raise the issue in the courts. I think he has raised the argument, interestingly, that the scope of Article 142 is narrow and that it doesn't allow for appointment of judges on a temporary basis. That is one view. The other view is, no, wait a minute. The framers couldn't have wished on us the problem we have today. After all, historically, there were judges appointed to resolve certain problems. Now, I can see where let me call it the Kabumba doctrine is coming from, in the sense that the way it works today is that if for instance, the Supreme Court is not quorate and you need to fill the quorum, you come and pick a judge from below. This is how we have a full bench on Susan Chigula. When Justice Egonantende sat on Susan Chigula, he was not a Supreme Court justice. Even Tinyefuza, indeed, when Justice Egonantende sat, even Tumukunde. And so the question becomes, if, and this is how I would frame the question, Elison, if with the current construction of the judiciary, when you and I started practice, when we left LDC decades ago and entered the field, backlog was a problem. In decades, not a decade, decades, more than one, we have not fixed it. Doesn't that suggest we need an alternative solution? Now, perhaps there's a middle ground. The middle ground is, if the problem is Article 142, maybe we need to go to the legislature and create an interim solution to this problem. And say, can we have a legal framework that creates mission-based judges to solve the backlog problem? Because you see, those who say it is subject to abuse, how then do they answer the argument that even the current appointment process has been accused or has been faulted by many as being infallible? It has been abused, to put it bluntly. How then do we say we won't solve a national conscience problem because the law provides for a system which has been abused and is now we must use? And by the way, it hasn't worked in over 20 years. There has to be another way to look at it. So my view is, anyone who argues that, I believe that we should have mission-based judges. And if the problem, and we can achieve it in one of two ways. We can give the litigators an option. Let Treasury provide and say, we agree, this is a crisis. To liberate 14 trillion, we will provide 5% of that amount to solve backlog. Let's just do math. If the Attorney General be right, and I have no reason to think he is wrong, if the AG be right that the cost of backlog in the courts today is 14 trillion, 10% of that is 1.4 trillion. Am I right? And it's in the commercial court. 1.4 trillion. Even if you take just the commercial court number, come and say that the people in the commercial court, most of them, maybe, I don't know what the percentage is, but most of them can afford a lawyer. Meaning they can make an informed decision that is not clouded by sentiment. Right? You come and say, what is 10% of 1.4 trillion? 140 billion. Treasury will provide 70 billion over 2 years to solve backlog. Then come and say, can we all agree on who the lawyers with integrity are? We write a list. Surely, out of 8,000 lawyers in Uganda, there are 200 lawyers with integrity. Provide a list. Then pass an instrument and say, all members of the commercial court will first make a decision whether or not your case should go to trial or should get out of the system and go to mandatory arbitration. Here is a list of 200 lawyers, pick one. Then you come and tell lawyers, you can go and sit in your law firm and make 10 million shillings a month. Or you can come and arbitrate and make 5 million shillings per dispute. When I was advocating for private-sided arbitration in 2016, I wrote a concept. And the argument I made was simple. For every adjournment in the courts, there's a lawyer involved. Simple. Even if the clients are appearing pro se, the judge who says, I'm adjourning this matter, has a law degree. So you want to solve adjournments? Convince lawyers that adjournments don't work. And economics has given us the answer. You want to change behavior? Change incentive. What are the odds that out of 200 people, 200, a lawyer who really wants a judgment will fail to pick one? You understand? Now, if the cost, because if you take 30% of that money as tax, even 10%, Elison, as tax revenue, surely Treasury can invest in this problem. Meaning, if you want to avoid mission-based judges, then create the same way we used to have mandatory mediation. You give us the choice and say, these matters, all of them, we are saying, first pick. You know what will happen? I will guess what will happen. My guess is this. The moment people realize, actually, this thing of arbitration, because as a lawyer, I will decide, if I be funny, of course we must disincentivize funny behavior. You take a bribe, we blacklist you, get off the list. You see? Now, you come and deliver fair decisions, we all agree, yeah. This is a fair outcome. Yes. We now go to the court to enforce. Then create an execution, bring back execution division to enforce those matters as a matter of priority. Now, I believe backlog is solvable. Why? Proof of concept, election petitions. If we can handle hundreds of petitions in 6 months, we can solve backlog. The issue is desire. We have chosen and said, election petitions are really important because we must have a parliament. We have even said, no appeal to the Supreme Court. And nobody says that is it fetters my right of appeal. No, nobody, to my knowledge, no one has challenged it. Which means we all agree as a country, this is a priority. If we believe that 14 trillion, redeeming it is a priority, let's find a solution. But it cannot be that the solution is not in the system that has failed to resolve backlog in over 20 years, ever since I got my law degree. So, I summarize by saying 3 things. 1, let us agree that this is a matter of national conscience. It is unfair for an accused person, regardless of the offense, to spend 2 years in jail waiting on a country that promised him a speedy hearing. That is unfair. 2, we can choose to solve this problem. 3, I see 2 options. If the consensus is that the wording of Article 142 is too narrow to allow mission-based judges, can we agree across party lines to create a framework, and I think the ULS can even participate in drafting the framework, to create a framework that says, actually now I've got another idea, a framework that says, let us bring this instrument to solve backlog. Let us draft it together and say, to avoid abuse, this is what the law should say. Take that law to Parliament and say, we are creating Article 142A to say, appoint judges for a period of so much time to resolve backlog. After that, they will lapse. The same way we had the movement system for 10 years to bring back peace and harmony. Now, my last idea is this. What was the last idea? Dear God, now it has gone. Let's make it scientific. Let's come and actually cost backlog. Then say, of course, there are other things we can do, like enforce judicial performance. Because if we are being honest, there are some courts where when your case goes, they say, But I think that point is well made. Moving on swiftly. If we make it scientific and say, the judges of this country are the guarantors of Clause 1 of Article 28. What happens if the system fails? But me, I would vote on the side of, this is a mathematical problem. If someone said to you there is $4 billion, by today's exchange rate, 14 trillion is on average, $4 billion. There, wouldn't you find a solution to it, to get that money? So let's go and tell Treasury, let's create, and by the way, there is a rule in the CPR, if I remember correctly, that says you can have trial by arbiter. It is there. That you and I can agree, we have decided, for us, my lord, you are busy, it's okay. We shall come back to you and tell you what we agreed. I handled the matter. Last story, I promise. I was handling it with a colleague who has since gone to the bench. In fact, I took over the matter from him, so I will not mention his name.
I think I was also in that matter.
And 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 we went to this judge. And when I took over, they had agreed. This was a reconciliation thing. It's numbers. There's no law here. So why don't you bring your auditor, I bring my auditor. You know how in land we say, bring your surveyor, I bring my surveyor. We open boundaries. So now you bring your auditor, we reconcile. So round one of reconciliation, the plaintiff had sued for 103 million. No, 132 million. Round one, defendant is up by 56 million. Okay, we shall come back. The client signed, the auditor signed. Round two. The defendant is up to 86 million. Plaintiff signs, auditor signs, defendant, auditor. Round three. Defendant is up by 38 million, above the claim. The defendant had counterclaim for 38 million. Plaintiff says, I'm not signing. The plaintiff's auditor signs the report. So now me, I take over at that stage. Matter has delayed, so my colleague is moving on. I am the defendant. So we go to court. I have prepared my witness. We are going for hearing. And we have, of course, I have told my witness, don't be emotional. I know it is painful. We have 6 hours preparing the witness. We walk into court. Justice Madrama says, before we go to evidence, address me on these reconciliations. My lord, my lord, my lord, my lord, my lord, my lord. He says, counsel, when you people are done, I want to speak to counsel in chambers. My lord, my lord, my lord, my lord, my lord. Actually, my lord, no, my lord. You see, my lord. Okay, I think I've had enough. Okay, actually, I will speak to the parties here. They are both doctors, they are intelligent. So, when you people agree to take this thing to auditors, you triggered this order of the CPR. This was trial by reference. Then my colleague for the plaintiff said, my lord, the reason why the defendant did not sign the third audit is that he had no valid license. The auditor that year had not renewed his practicing license with ISPAO, Institute of Certified Public Accountants of Uganda. So that can't be valid. The Honorable Mr. Justice Madrama of the High Court, as he then was, looks at our colleague and says, counsel, if you sit in a car with a driver and he drives you from here to Mombasa, then you reach there and you discover,
He has no permit.
the driver had no permit. Does that change where you are? He said, I'm entering judgment for the defendant. Anything else we should argue about? So I stand up, I look at my colleague, I turn to my client, says, I'm leaving that. I say, interest cost, says, I'm leaving that to you. So I look at my colleague, it is a bad day. So I said to him, I said to the judge, my lord, in the counterclaim we had claimed damages and interest, but we'll waive those claims. We are grateful for your decision. So I want to finalize this. We're grateful for your decisions. My plaintiff, my lord, we are maintaining our claim. We still think we have a good case. I stood up. I said, my lord, on second thought, I think I spoke too hastily. Now, actually, we will maintain damages and costs and interest. He says, did you claim? I said, yes, where? Counterclaim, my lord. Here is why I tell you the story, Elison. Justice Madrama gave us special damages as prayed for, as awarded by the auditors. He gave us interest and costs. He gave us interest at 19%. Guess what? This date of hearing was 6 years to the day since the case had been filed. There had never been a witness. There had never been a trial. 6 years. How was the case resolved? Auditors. You see what I mean? Now, when we computed the 19% on the 39 million, guess what? We were above the plaintiff's claim. The plaintiff fired that lawyer and went to a different law firm. The senior lawyer in that firm called me and said, Mr. Kirunda, how are you? My name is, I'd like to come and see you. But I said, you're my senior colleague, I'll come to you. He said, I have read this decision. They've advised my client to appeal. I don't think there's anything to appeal. Can we agree on a payment plan? If you treat backlog as a need between people, forget about legalese. Forget about the limitations of Article 142. Just say there are two people arguing about a piece of land. There's a woman who is accused of having murdered her husband. There's a child at home who needs fees. Strip it of the legalese and say, is this a problem we can solve? And get scientific, whether through auditors or through lawyers. Treasury needs to invest in solving backlog. We need to agree the old system has not worked. We need a mission-based approach to resolving backlog. I hope that helps. Thank you.
Thank you very much. If you're just joining us, we're coming to you soon. But welcome to Judicial Service Conversations. I just want to make a quick response. Treasury has actually increased the budget of the judiciary from 120 billion to 400 and coming to, I think, 500 or 600 billion. So there's actually no problem at Treasury. The problem is you talked about 20 years. We had one time on this space, Dr. Elison Karuhanga, who told us that when he graduated in 1973, he was put on a committee to resolve backlog. So it's not just it's a generational problem, which was solved with Article 142. And I just want to point out the language of 142 is that where, and I'll just go to the third one, which says that, now for those who don't know, Article 142 is an article of the Constitution of Uganda about the appointment of judicial officers. And it says that where the Chief Justice advises the Judicial Service Commission that the state of the business in the Supreme Court, Court of Appeal, or High Court so requires, the state of the business so requires, the President may, acting on the advice of the Judicial Service Commission, appoint a person qualified for appointment to act as a justice, and then it says in clause 3, for a period of the appointment. Now, or if there is no period, until such time as the appointment is revoked. So I understand there have been many conceptual arguments, but our argument here on the Judicial Service Commissions has been that the clear wording of the statute is a person qualified, that includes an advocate, can be appointed where the state of the business so requires. And in my view, the state of the business so requires. Right now, we have tried everything. Technology, ADR actually, mandatory mediation. We've tried, what was the last thing that they tried? Plea bargain. You know, plea bargain, I'm sorry for judicial officers who are listening, but plea bargain is equivalent in Uganda to hostage taking. In the United States, where they have a high rate of plea bargaining, you have also custodial limits on sentences. You have to make sure that the case can be heard by a certain period of time. Delay cannot be the ground that you're going to be on pre-trial remand. Someone spends 10 years. You imagine, 21 years, you gave us an example. There are actually appeals that are taking an appeal. The Chief Justice wrote a letter recently saying that he has criminal appeals that are more than 10 years old. What the man is going to finish his sentence before he finishes his appeal. But I think what we've just had is and I just want to read a comment I have from a regular listener. Says that Mr. Robert Kirunda articulates his perspective with remarkable passion and conviction, not to mention thoughtful insight. And I think I agree with that.
Elison, may I just thank all our listeners, for investing their time in us. It is not easy to keep somebody for as long as we have. We are basically, I think we have taken hostage. We have taken them hostage, really.
We have.
But also for the very kind words that they have said. But I must again thank you and everyone here for providing a space in which we can have honest and candid conversations. Thank you.
Thank you. If you're just joining us on Judicial Service Conversations, we are pleased to... If you're just joining us on the Judicial Service Conversations, we are pleased to inform you, of course, as we usually do, that you're late. We are winding up right now. We've had the wonderful Mr. Robert Kirunda, who has served us well tonight. He has not merely answered our questions, he has illuminated them. He has not just dealt with issues that bring heat and passion, he has attempted to shine light onto the solutions to the many problems that we have. He has reminded us that arbitration doesn't mean it's escape from justice, but rather arbitration is an instrument of justice. He has told us about innovation, lectured us on AI. He has told us about the power of artificial intelligence, that it is not the end of advocacy, but it is a summons for us to be deeper. He has spoken for constitutionalism at its core and the right of lawyers to practice their profession. He has spoken to us in a solemn and powerful, articulate and humorous manner about the matters that touch and concern the country. And as you can see, colleagues, the future of justice is not shaped by noise. It is shaped by serious minds, by steady hands, by institutions willing to examine themselves, and by lawyers who pay deep attention and provide deep thought to the contemporary problems of our time. Robert, you have given us depth where sometimes there is haste. And you have given us clarity where many times there is confusion. And I think we've not had in a long time as big an audience as we have, which is an audience really that's really about you. A lot of people were yearning to listen to a man of such depth, of such intellect, of such integrity, of such honor, and of such brilliance as you. And I am as you. And so I think we've got a lot of comments. I would have gone to some of them. Winding up comments. I saw comments from people. I was going to read a comment from I see comments from Angelo Izama. I see comments Ivan Okuda, who was asking you to share a career entry with lawyers and your success tips, but we shall spare you that question. I see NBS Television retweeting you. I see Janice Chakundwa. I was going to read her comment in full. Maybe I should. But maybe I shall not, for the simple reason that I have seen it's quoting a matter where I am involved, and I don't want to be accused of mobilizing public opinion in matters before the courts. But be that as it may, allow me to, on behalf of this, our Parliament of the Bar, in special session, really thank you, Robert, for coming. Thank you for speaking. Thank you for your time. Thank you.
I have to say, Elison, I was looking for our audience. I was looking behind me because I think Elison is talking about somebody else, not me. but I must thank Elison for also being always someone who is curious and making it easy to have difficult conversations with joy and humor. I was telling your colleagues when you stepped out before we started that you and I have disagreed on many a point. And yet after all these years, we are yet to throw fists at each other. but I must also, perhaps in closing my parting shot, incidentally, I almost pushed back with you on the point of, let me just take you one step back. The budget of the judiciary. The question then is, why aren't we creating backlog as a specific item, budget line, to say this money here is ring-fenced to fixing backlog?
They do.
But and yet it doesn't go away.
They
and
do.
Therein was my point. But let me not walk you back from where we've come. Allow me to use this platform to say something to our younger colleagues on the bar. We were young once. We are now.
We are young.
and in the eyes of many, we are still young. But treat your early years in the profession as an audition. and don't waste it. It is easy right now to chorus in a crowd. In fact, there is that popular phrase, but that one will cause us problems. Let me not go there. But take some time to pause as an individual and reflect on your personal journey and make your choices wisely. If I could say one thing to a young lawyer today, to a younger advocate, that I wish someone had said to me, or that I wish I had listened to when some people said this to me: pick your mentors, pick them early, pick them wisely, and more importantly, listen to them. There is wisdom in the Chiganda expression, eriso ly'omukulu awadugala we walaga. Those of us who have a few more years ahead of you have made mistakes. We have also had lucky breaks. We are where we are because people believed in us. I would like to think because we invested time in making ourselves believable. These are not skills we teach at the law schools, and maybe we should. But a lot of that doesn't happen in the crowd. So take a step back and ask yourself. I like to talk about the man or the woman in the mirror and have that conversation with the man or woman in the mirror and say, 10 years from now, looking back on our journey, what will we be talking about? Will we have friends that we can reminisce back on? I remember the ULS EGM about whether or not to renew Chief Justice Benjamin Odoki, to extend Benjamin Odoki's tenure. Elison, Nicholas, myself were there, and my God, did we make furious arguments. When you meet with the man or woman in the mirror 20 years from now, will you be proud about the things that you are chorusing about now? This profession here is for all of us. And our senior colleague, Ladislas Rakafuzi. I mention these names because I want to give credit when people are alive. Said to me he learned a lesson from senior counsel John Katende, who told him, clients come and go. You and me, we stay in this profession. These are simple things that, and we were at the Supreme Court, he said it to me, man, I almost failed to argue that day. I say those things because thankfully we were on the same side, just for context. I say those things because there is wisdom you will learn from senior lawyers that you won't hear in a courtroom, you won't hear in a public space, you won't hear on X spaces, but it might help you. So if you're wondering, to answer Ivan's question in a sentence, if I was to give one tip to a young lawyer or someone younger than me today, if I was to wind back 20 years and think of myself and say, what could I have done differently? I would have picked my mentors and coaches. Those two are different. You know, it's amazing that in the world of sports, the most seasoned sportsmen and women who have won all the trophies in the world, Michael Jordan respected his coach until he retired. But we never think of coaches in the services industry. I would have picked my coaches, I would have picked my mentors early, and thank God, the few that I had, I listened to them. And that has helped me a great deal. Thank you for having me, and I really, really wish you a wonderful evening.
Maybe just what we usually do here at the end is we play a song about me. But in the last few weeks, people have been saying we should not play a song about me. So if you were to give our young lawyers, last week we had Jude Biamukama. I don't want to tell you the song which Jude proposed, but now if you can just tell us what particular song should we end with. Jude's was quite epic, but no pressure.
Elison, I have to say this is one I didn't see coming. I can't think of a song off the cuff. My taste in music is not the most palatable, but I will use the opportunity to do something I would have done in a different context.
You can sing.
If you, no. Not today. I'll use the opportunity to do something I would have done in a different context, and maybe I may well do down the road. But perhaps I will pick for my song the famous. No, not all the way. The famous Afrigo song, Ori Mujawa. And I hope therein lies my message to our listeners. Thank you.
Ended. Yep. You had 53,000 listeners.
Olimuja w'omusajja singa, olimuja w'omusajja singa nze, olimuja w'ggwe, olimuja w'omusajja singa, olimuja w'omusajja singa nze, olimuja w'ggwe, olimuja w'omusajja